So are we good? You guys are good?
I think we're good.
What did you say?
I can't tell. The mic.
This mic? So bring it.
mic.
Thank you.
Okay.
Hello all. So we'll start the second panel. Bob Fleischner is going to join us very, very soon. Late this morning, early this afternoon, we're going to talk about ethical issues in guardianship. The panelists will introduce themselves when we go through, but the quick one, we have Judge Dunn from Suffolk Probate, Karen Talley from CPCS, Carlos Zimmerman-Diaz from DMH, and then Bob Fleischner you heard from this morning. So we have a hypothetical that's in your packet, but because we're talking about ethical issues and we want it to be timely, we're also going to talk a little bit about some of the issues that were brought up in the last panel. One quick one, I think, to bring up maybe the issue of bringing the matter, if there's a guardian in place and somebody's getting towards end of life, and there's a question of whether one should go into court to ask the judge for permission or to expand the guardian's authority to consent to a suspension of life-sustaining treatment. And sometimes there's a difficulty of how do you get in quickly, and when do you get in? I don't know if the panelists have any thoughts on.
Well, I'll touch on that briefly, and really the answer is you need to make a pain of yourself because the court says are not up to speed on the guardianship matters maybe as much as they should be as a general rule. So I think if you don't push and push to get that matter in court and you file something and then, let's even say there's not a guardianship in place or whatever, and you file a motion for counsel and a motion for your speedy hearing and then you wait 3 or 4 days, that time's gone because you really would, you should continue to push because right away you need to get counsel appointed on the matter basically the same day you're probably filing it so that counsel can go out, there can be, because you're going to have to do the service that was mentioned, et cetera, et cetera. I have no statewide answer to how can this matter be heard quickly except to say you need to, as the petitioner's counsel or who's ever bringing forward the matter, it could be the guardian on certain aspects, you need to really push that matter forward or you're not going to get heard, because it's going to get kicked to the side. So, not a great answer, but that's what it is.
It is what it is.
Yeah.
I would just add to that, and Judge Dunn is aware of this, that CPCS attorneys have been required to re-register, and as a way to accommodate the court, the petitioners, all the parties involved, one of the questions we ask them to answer upon re-registration for a guardianship panel is whether they're willing to be available on short notice for emergency cases, and so they answered yes or no, and then if so, what's the best fax number, and the court has agreed to fax pleadings to them. So, obviously we understand that counsel needs to be appointed, but we're doing what we can do as well to try and facilitate that.
And that's a new that's something that's come out we've worked on the last few months. So the problem is recognized, it's not exactly solved, but it's being addressed, so.
And from my standpoint, working for DMH, one of the most important points made by Judge Dunn was just to have everything teed up ahead of time, whether that's getting your clinical affidavit, getting the petition to expand, having some affidavit of necessity ready, motion for short order of notice, having counsel, maybe even having contacted a counsel ahead of time, having one in mind to suggest to the judge, just have everything ready so when you walk it in, you may be able to be heard that afternoon if possible, or if CPCS might need more time, you're allowing them a window of opportunity to get an IME or whatever other relief they might seek to help guide them through what may be a case in which they'd need an expert opinion because they are lay attorneys. So,
Quick addition to that, I've had one. So I think making a pain of oneself is absolutely the thing to do. The counties that I seldom go to, I've said out to the clerk, I'm not leaving this courtroom or courthouse until I get it. Counties I go to a lot, I don't have nearly the guts to do that. But in one county I go to a lot, we were able to get through and go before the judge, and he said he would not expand the authority because it wasn't ripe quite yet, which I always thought was unhelpful to give. I thought it was disrespectful, and not your county. It was disrespectful, disrespectful to a disabled person, because me as ostensibly having capacity, I could sign a DNR anytime I want. But this incapacitated person doesn't have that option. So to say that she needs to wait until it's on the eve of needing something intrusive, I thought was unethical.
Can I suggest a reason why? Not that I know why the judge did what he or she did. The difference, and I appreciate that for all of us who have capacity, advanced planning is the ideal and is the goal. I think the difference is for a person who has been adjudicated incapacitated, once that DNR is entered, it's irrevocable for all intents and purposes. And I think in terms of ripeness, the terminal illness issue is a threshold matter that I think we may need to explore. And I understand all the considerations in terms of the time and stuff, but I don't, we have certainly seen petitions where the purported illness, terminal illness, is dementia. And there's nothing else to indicate that other, but for a DNR, DNI, as Lisa was referring to this morning, the natural course would be that the person would die imminently. So I think those are a couple of the considerations.
I'm going to defend my unnamed colleague because I think I probably used that same term without saying ripe, I guess, because I don't think that sometimes they bring it in prematurely that the person is not acutely ill at the time, and I can't make a substituted judgment that they wouldn't want any of this other treatment. It has to be, unfortunately, I think it has to be almost in a crisis, because if it's not in a crisis, I can't say what their substituted judgment would be because their conditions change so rapidly. So the matter will come in from the hospital and they'll say, oh, he has end-stage renal disease. Well, okay, whatever happens, and it's put on for a period of time, and then later, oh, he still has end-stage renal disease. And I understand what Dr. Warren said, people get 6 months and they're dead in 2 weeks because people want to be optimistic, but we also run the opposite gamut in some of these reports that it's like, oh, this person is dying, and then they graduate hospice. So it's very difficult to make a substituted judgment of someone when it doesn't seem that they're in crisis. And I pass on those now and then, too.
And I would just add that I think there's support for that in Guardianship of Linda, which talks about not making prospective substituted judgment determinations.
I think that's absolutely correct. I completely agree if it's not ripe, but also I think it's unfair to ask for substituted judgment, and that makes it much trickier. I still think there's something missing that I could do a DNR, but an incapacitated person could not. And I don't know if there's any answer to it, but just I think it's an ethical issue that maybe next year we'll put more time to. Yes. So other issues from the last panel folk want to talk about? Barring that, do you want to talk 1.14?
Sure, okay. Thank you. And before I get into Rule 1.14, I just wanted to thank the Social Law Library and the Mass Guardianship Association. Some of you may or may not be aware that this used to be the conference, the annual conference that was sponsored by Suffolk. When they were not able to do it, people really came together to resurrect it in this form, and it's no longer a one-day conference, but it's been split in two. But I just think it's a really nice opportunity to have all the varied perspectives together in one room. Petitioners, guardians, petitioners' counsel, respondents' counsel, judges, the view from the bench. So I just, we talk amongst ourselves and we fight it out in court, so it's nice every once in a while to have these opportunities. So thank you to the organizers. When we're talking about ethical issues, I actually asked them to put Rule 1.14 up on the screen because I know it's in your materials, but I want to do a little bit of sort of parsing of the language of the rule, and I thought it was helpful to have it up there so that people could refer to it. So and Gary, how much time do we have individually?
Do you want to do 15? Does that work?
Yeah, that's fine.
And that's Mass Professional Rules of Conduct. The 1.14 is Mass
Yes,
Professional
yes,
Conduct.
yes, correct. Okay. Okay, so just to give you an overview, I want to talk about Rule 1.14 generally, and then I wanted to talk about how it intersects with the CPCS performance standards and the role of Respondents Council, and then if we have time, maybe give some illustrations, or I'd love to take some illustrations or questions from you about, you have a particular scenario, what would I do under Rule 1.14 and what would be permitted. So if, as you can see, and I'm sorry if, as I turn my head, if the mic is, if it's not picking up. The Rule 1.14, as Gary suggested, it's in the Mass Rules of Professional Conduct. Its title is Clients with Diminished Capacity. So the overarching principle is found in subsection A, and that's to maintain a normal attorney-client relationship as far as reasonably possible, even if you believe or suspect or have very good evidence that your client may have some form of diminished capacity. Okay, so that's the requirement of Rule 1.14. And I'll just read it. It says, when a client's ability to make adequately considered decisions in connection with representation is diminished, whether because of minority, mental impairment, or because of some other reason, the lawyer shall, as far as reasonably possible, maintain a normal client-lawyer relationship. Okay? So like most rules and statutes, it's very carefully drafted. There's a lot in there, and I thought it would be helpful to unpack it because there's a bit of confusion about what Rule 0.14 requires or permits or its applicability to certain situations. So the first thing is that it's the ability to make adequately considered decisions. So like we see in other areas, that needs to be differentiated from, whether or not the individual agrees with you or is accepting your advice or doing what you think is in their best interest. So that's, I think, the first qualifier, is that it's an ability to make adequately considered decisions. It's like informed consent in that respect. It's not the product or the end result of the decision-making that we're looking at, but it's the process. So it's not whether we agree or disagree with the client's decision that we look to, but rather their process. Is the client able to reach a decision as a result of adequate consideration, or is that capacity somehow diminished? The second qualifier, which I think is important just to be aware of, is that it's in connection with a representation. So again, I think that's another sort of limiting factor. It's not sort of a general duty to protect other individuals who we may encounter through our role as attorneys in just general matters. In guardianship, so again, the lawyer's role is considering these issues as they're related to the representation. And in guardianship cases, the subject matter of the representation is fairly broad. So, it may be broader than in other kinds of litigation, but it's important to keep that limiting language in mind. So the third thing about subsection A is that even where the ability to make adequately considered decisions in connection with the representation is diminished, again, the rule requires, and uses the word shall, requires the attorney to maintain as normal an attorney-client relationship as possible, okay? So that's the general rule. Gary, do you know if we want to take questions at the end or in the middle or at the end of each?
Good to have it go direct.
Okay.
See if it goes too much.
Okay. So that's the general rule. That's the mandatory part. The second part is subsection B, which is permissive. It permits but does not require the attorney to take reasonably necessary protective action. And again, the reason why I want to have this up here is to talk about the specific language of this, because I think sometimes it's misconstrued. When the lawyer reasonably believes that the client has diminished capacity that prevents the client from making an adequately considered decision regarding the specific issue, part of the representation, is at risk of substantial physical, financial, or other harm unless action is taken and cannot adequately act in the client's own interest, the lawyer may take reasonably necessary protective action in connection with the representation. And then it talks about the different options. So again, I think there's a lot there that needs to be sort of parsed out carefully. The first is that the lawyer's belief must be reasonable, okay, that the client's diminished capacity prevents them from making an adequately considered decision regarding a specific issue. So again, it's not a matter of, he's not taking my advice, ergo, he must be crazy. And so, people are laughing, but there's a really good decision that I like from New York. It's called People versus Picozzi. And it's in a competency to stand trial context in criminal defense, but they have the same legal standard as we do for competency to stand trial. But I like it because it sort of operationalizes the definition in terms of what capacities you're looking for, and it makes very clear that if the decision was the result of the application of those capacities, that it takes a very functional approach. The fact that the client disagrees and is like disregarding the attorney's advice doesn't mean they lack capacity. So that's just sort of provides an illustration of that. Second is that, again, the inability to make adequately considered decisions regarding a specific issue that's part of the representation, so all that qualifying language is there, must place the person at risk of substantial physical, financial, or other harm unless action is taken and the client cannot act adequately in his or her own interest. So the risk of harm has to be substantial, physical, financial, or other harm unless action is taken. So what does that mean? That's a big question, and a lot of people have written about it, and a lot of people have different opinions, and Bob Fleischner, I don't know if it was included in the materials, but has a good article in Clearinghouse Review. Maybe he can, I know he submitted it, but we kind of pulled him onto this panel a little bit late. So has a very good article in Clearinghouse Review that talks about the various views of this rule. And certainly Paul Tremblay has written articles about what that means and what kind of harm meets that standard. So why don't we take the easy part first, which is, and this is just what it means to me. It means to me, unless action is taken, that it's likely to occur, the harm is likely to occur, and is not otherwise preventable unless the attorney acts. And people are free to differ with that interpretation. I'd be happy to hear other points of view. But that's what it means to me, and I think to put that into practice, it involves an analysis of the risk and the likelihood that no other protections are likely to avert the, the risk without the attorney taking those steps. Okay, so that includes an assessment of whether the client, in spite of his or her diminished capacity, through attorney counseling, is able to take steps to prevent the harm. So an example would be, you counsel them, you tell them about your concerns, and with their agreement, they agree to either themselves or to allow you to contact a friend, a family member, a service provider, a physician, their primary care, whoever it may be. And that's not just abstract. I know that Bob and I have both dealt, not infrequently, with clients who let us know that they are feeling, suicidal. And we may be the only person at that point that they are telling. I have always dealt with that successfully by letting, I say successfully, meaning that I've never had a client refuse, by counseling the client and saying, will you permit me to contact your outpatient, provider and to put these things in place? So it doesn't have to be an either-or proposition. You can respect the client's autonomy and decision-making capacity. You can respect the attorney-client relationship, and through counseling, also, take those protective steps. I think that is a less restrictive alternative than, going sort of beyond the client or revealing client confidences without the client's assent. That may not always be possible, but I can tell you from personal experience, it is possible to do it that way.
Can I ask you an ethical question about that?
Sure.
So let's say that you were meeting with a client, he discloses that he's suicidal, actively suicidal, he's outpatient, and you ask for permission to disclose that to providers, and client says, no, I'd rather you not. I want to have the right of self-determination. I don't want this guardianship because I want the right of self-determination, and I would like to have the right to decide when I die.
Yeah.
But what would you do in that case?
The times, it hasn't been in the context of a guardianship case when I've dealt with this, and I've had sort of an long-standing. Bob, have you ever had that situation? I think Bob may have had that situation. So can I just ask you how you dealt with that?
Absolutely.
Because my clients have always agreed.
Yeah, I've had it twice. where in one, I had a client disclose to me that, these are both in the context of civil commitment, disclosed to me that he hoped he'd get out of the hospital because he intended to take his life. Nobody in the hospital was aware of that. The petition was based on the third factor in civil commitment, which is that he was unable to take care of himself in the community. So it was a parents patriae commitment, not a danger to himself commitment. I counseled him, suggested that he find a clinician with whom he trusted, who was not a hospital doctor. He declined to do that. I have to say that I was younger, and I went forward with the hearing without disclosing that he was discharged. He did not kill himself. If I was faced with that now, I'm not so sure that I would be as sure of myself as I was when I was 30-something. And so I haven't faced it since I've been in my mid-30s. But I think I would probably go forward again. I don't think that and I think, I did in preparation for the article that Karen mentioned in Clearinghouse Review, I did a review of every state ethics rules boards that I could find, looking to see if a lawyer was ever disciplined under Rule 1.14, and I can't find a single one in the country where there are cases where the ethics boards or the chief court of the state considered 1.14, but always found that if the attorney made a reasonable decision under this rule, that he or she would not be disciplined. Now, that doesn't comfort me much when I'm faced with these kinds of decisions, except that I think that at least I won't be disbarred, whatever I choose to do, whichever way I go, if I disclose it or if I choose not to disclose it and there's an outcome. The second case was a little different, because in the second case, the client did not tell me he wanted to kill himself, but I had a pretty good, I had a vibe, if you will, that that's what this was about. He was an individual he was a very thoughtful young man who had very seriously abused his infant child. And he was extraordinarily remorseful about that. And I just thought that that something bad was gonna happen if he got discharged. The petition, the hospital, the doctors didn't get the same vibe. And I'm not criticizing them or saying that I'm better. I just had it. We got him out. It's the longest commitment hearing I ever did. And we actually got to do it at the courthouse, which was very, very good. And there just wasn't much evidence that the Department of Mental Health had. He was discharged, and within a month, he walked out in front of a car on an interstate highway. I still think I did the right thing, but I'm not sure. So I think these decisions are very, very, very tough. And I think I come out for client autonomy. I think that for both of these individuals, this is a very philosophical discussion, which I'm also not sure how this comes out. I think that that a rational person can decide to kill themselves. I think that is not necessarily the action of a mentally ill person. I think in both of these cases, the pain that these men carried and the inability of well-meaning, good clinicians to help them deal with it was profound. And I don't think it was a product of delusions or of schizophrenia, or it definitely was related to deep depression, but I just felt it wasn't my role to intervene in that.
I also
Can't
think,
you- oh,
Gary,
please.
I was just going to say, in guardianship cases, we sometimes get a lot of pushback when we're asking for IMEs, and we always say, well, we're not we're not doctors, we're lawyers. And so, in a case where it was a guardianship case and you did have an IME involved, that would be another option, because sometimes we've had, even in Roger's cases, our IMEs can talk to individuals and, get them, they just talk to them sometimes in a different way than the hospital doctor or the treating clinician. It's within that agency relationship, so it doesn't go anywhere, but that gives us, I think, one other tool if we have an IME involved in our cases, so that we're not in the position of trying to, make a clinical determination. Is this person really at risk of suicide unless I take steps?
There's an ethical question. Do you get an IME for a client who you think is suicidal, who then has some obligation, may have some obligation, may say that, maybe there isn't an obligation. Let's say that what the person was going to do is something that would make the doctor a mandatory reporter. Is the doctor protected by the fact that he's an IME in a case? I don't think so. Maybe.
I think for client counseling, it gives you one other person to help engage in that client counseling.
And in one of the cases that I described, I reached out to a doctor I liked a lot and talked with him about it without disclosing the identity of the client. And he told me to disclose, and I chose not to. But it was helpful to me in thinking it through.
A quick follow-up that I wonder if, so typically the motions for IMEIC asks the judge to direct the IME not to disclose information anywhere other than to respondent's counsel. So I would wonder if having that court order would preclude the clinician from disclosing. And if it would, there's a question, ought the motions give an out to the clinician that, except for other professional obligations they have?
I think the language is until or unless instructed by the client's attorney.
So then you could prevent the doctor from disclosing. And I would also argue then you're passively permitting the doctor to disclose. So I don't know if that makes it more ethically murky.
Yeah, I knew we were going to get into some murky waters here. So
I don't think that the IME order, and I'm going to have to start reading it a little closer when I approve it, that it stops the doctor, who's a mandated reporter, to be able to report something that they think they need, they're ethically obligated to report. I'd find that hard to believe that was the situation.
Well, it's also if the IME, after you've consulted with your medical examiner, says to you, in my opinion, a temporary suspension of that autonomy is best for longer-term autonomy for this person. I mean, what would you do as an attorney under 1.14 in that situation if they're recommending that to you?
in what context? When you say a temporary suspension of their autonomy, what do you mean?
Whether it's in the context, let's say it's in the context of guardianship, and they say, in my opinion, I think that this is required even on a temporary basis. Would you not use the IME at a trial, or would you still go forward?
I think a lot of that is case dependent. I mean, we use the IMEs for lots of different purposes. It can be consultative, it can be testimonial, obviously, and I think that under the UPC, where we're looking either under a temporary, obviously, to make sure it's an emergency, and if there is an order that it's tailored and goes no further than the exigency, but also with an order of guardianship, that the impetus toward limited guardianship and full exploration of less restrictive alternatives, including maybe a healthcare proxy or durable power of attorney, if the person has that capacity, that gives us, all of us, in some respects, all parties, everyone on, from judges to respondents' counsel to petitioners' counsel and the client, that in some degree, we all have the same goal, which is the most limited, explore the other alternatives, and then the most limited intrusion on the person's liberty.
Well, what if what if their express preference was to have that, whatever, the procedure, the treatment? Are you saying that your judgment as an attorney in that tactical decision would override the client's express preference?
I might cut in,
okay.
and I wonder if let's wait for the hypothetical.
Okay.
Let's go to that.
Okay.
Excellent question. Let's in a little bit, let's go to that one.
Okay.
Make sure we get to it.
Okay. Do you want me to finish Rule 1.14, or?
Just a few more minutes.
Real quick, okay. So, at any rate, back to subsection B, again, I think that the bottom line is there's a lot, written, there's a lot of various viewpoints about what the attorney, is allowed to do in terms of assessing the risks, what constitutes substantial harm. But I think we can reasonably say what it is not. And I think it's not a sort of general duty of protection like that of a mandated reporter, and that it's not untethered from the specific issues involved in the representation. So I just want to talk briefly, and again, as I mentioned before, Part A is mandatory, it shall, Part B is permissive. And I also think, just like we just said, that, there is a duty, although it's not explicit in this rule, there is a duty, I think, to explore less restrictive alternatives, and if, whether it's through your ethical duties or whether it's through the court litigation, to fully explore least restrictive alternatives. And I think some of that language is found in C, where it says information relating to the representation is protected by Rule 1.6, which is the duty of confidentiality. There's an implicit authorization when taking protective action pursuant to paragraph B to reveal information about the client, but only to the extent reasonably necessary to protect the client's interests. So again, it's permitted, not required. But I think that general thrust of, intruding on a person's liberty or autonomy only to the extent necessary and to have it be narrowly tailored. Yes, it's in the MUPC. I would argue that it's in Rule 1.14, but it's also sort of a bedrock of constitutional jurisprudence, period. It's not simply the rule and the MUPC. Okay, so just briefly on the intersection of the rule and the CPCS performance standards. If you look at our performance standards at footnote 2, they do specifically address the intersection between Rule 1.14 and the taking of protective action, and they refer to comment 7. Comment 7 to Rule 1.14 specifically mentions civil commitments, but I think we would argue that, guardianship is similar to that, in which it's such a massive, intrusion on the person's liberty that there are other players. We are only assigned in cases, civil commitments, guardianships, where substituted judgment, where another party, another entity is pursuing that litigation for the specific purpose of taking protective action. So my position is that Rule 1.14 has fairly limited applicability in our cases, and that our performance standards and the case law, like Sikowitz, like Rogers, helps to define our role, and that we don't often need to look to Rule 1.14.
A quick follow-up to comment 7 of Rule 1.14. I think it's the last sentence that has a conflict, I think, between what counsel may have to do under CPCS rules.
I'm gonna see if I
And
can.
Bob, I forget what the acronym was, but under supporting the client, that it says that counsel should follow the client's express preference if it does not pose a risk of substantial harm to the client, even if the lawyer reasonably determines that the client has not made an adequately considered decision in the matter. So you have to do what you have to do, but I wonder if there's conflict with the concept of supported decision-making. It sounds like that violating this would be saying you want the guardian, but I'm still going to object. And I bless you for being on the panel for them. Sorry for, go
Yeah.
for it, Bob.
Mike, I think there's a lot in Rule 1.14 that actually is not helpful, and that is very confusing. And if you look at the literature on 1.14 in the law reviews and things, it's almost universally criticized as not being a helpful rule, because some people criticize it for being confusing, others for limiting actual, for saying in the first sentence you create an attorney-client relationship as much as you can, and then spend the rest of the rules in the comments on how to undermine that. So I think, but for me, what is useful in the rule is that so much of the decision-making is left to the lawyer, which is a little unusual, I think. The lawyer decides whether the person's makes a reasonable decision about whether the person can make decisions, whether they're impaired, whether to violate the other canons of ethics and so on. So I think the last sentence can be interpreted lots of ways, and it is only a comment. It's not the rule. There's a great line in Pirates of the Caribbean where, Johnny Depp, somebody's straggling behind, and Johnny Depp says, "Them that stays behind get left behind." And the guy keeps straggling behind, and Johnny Depp goes back to save him, and one of the pirates says, "Well, what happened to the rule?" And he says, "Well, it's more of a guideline." So I think that the comments are sort of a guideline. I take the Johnny Depp approach to the Jack Sparrow approach to Rule 1.14.
Okay, thank you. Carlos, do you want to talk about 1.18? Maybe say where that's from, where 1.18 is
Yeah,
from.
I'm just going to briefly touch on Supreme Court Judicial Rule 1.18 on the Uniform Rules of Dispute Resolution. These rules govern court-connected dispute resolution services provided in civil and criminal cases in every department of the trial court, including probate and family court. So in what I do, I work as Assistant General Counsel at the Department of Mental Health. We are in a unique position of serving consumers of DMH services, mental health services, and also at times serving as a petitioner in a guardianship case in which we're asked to suspend the liberty interests of our consumers, even on a temporary basis. So in the pre-filing stage, what I normally do is what you would do in any litigation, any case as an attorney, is I ask my client what your goals are. And in doing so, I also, under Rule 1.18 of the SJC rules, sub-Rule 5, I am instructed that attorneys shall provide their clients with information about court-connected dispute resolution services, discuss with their clients the advantages and disadvantages of various methods of dispute resolution, and certify their compliance with this requirement on a civil cover sheet or its equivalent. So what I usually file is what's called a Uniform Counsel Certification Form. And we often do not use the court-connected dispute resolution services. However, I find this discussion with my